The Judicial Branch. Good afternoon, everyone. Today we turn to the Judicial Branch, the third branch of government established in Article 3 of the Constitution. While Congress writes the laws and the President enforces them, the courts interpret and apply them. But more than that, the judiciary often plays the role of referee in American politics, deciding disputes, defining rights, and sometimes even reshaping the direction of the nation. Constitutional foundations. The Constitution provides only a broad outline of the judiciary. It creates a Supreme Court but leaves the structure of lower federal courts to Congress. Judges are given lifetime appointments subject to good behavior. This design was intentional. It shields judges from political pressures and allows them to make decisions based on law rather than popular opinion. Still, the Constitution says little about how powerful the judiciary should be. Its authority has grown over time, especially through the power of judicial review. Judicial review. The case of Marbury versus Madison, 1803, firmly established the principle of judicial review, the authority of courts to strike down laws or executive actions that conflict with the Constitution. This was a landmark moment in American constitutional history. Chief Justice John Marshall, writing for the court, famously declared that it is emphatically the duty of the judicial department to say what the law is. Although the Constitution itself does not explicitly grant the courts this power, Marshall reasoned that the very structure of the Constitution implied such authority. If the Constitution is the supreme law of the land, then any ordinary law that violates it must be invalid. But for that supremacy to have meaning, there had to be an institution capable of interpreting and enforcing it. And that responsibility fell to the judiciary. Judicial review gave the Supreme Court a co-equal role in government, ensuring that neither Congress nor the President could exceed their constitutional limits without being checked. This ruling positioned the courts as the guardian of constitutional principles, balancing the powers of the legislative and executive branches. Over time, judicial review has been exercised in cases ranging from civil rights, Brown v. Board of Education, 1954, to presidential authority, United States v. Nixon, 1974. Today, judicial review remains one of the defining features of American constitutional democracy. While some critics argue that it gives unelected judges too much power, defenders see it as essential to preserving the rule of law and protecting minority rights against majoritarian abuses. In practice, it ensures that the Constitution is not just a symbolic document, but a living framework that continues to guide and limit governmental power. Structure of the federal courts. The federal judiciary is organized in a three-tiered system designed to handle cases efficiently while ensuring fairness and consistency across the nation. 1. District courts, trial courts. At the base are the U.S. district courts, which serve as the general trial courts of the federal system. There are 94 district courts across the country, including at least one in every state, as well as in the District of Columbia and U.S. territories. These courts have original jurisdiction, meaning they are the first to hear cases involving federal law, disputes between states, or cases involving the U.S. government. Judges oversee trials, rule on evidence, and instruct juries, while magistrate judges assist with preliminary matters. The vast majority of federal cases begin and end here, with outcomes ranging from civil settlements to criminal convictions. 2. Circuit Courts of Appeals, appellate courts. Above the trial courts are the U.S. Courts of Appeals, divided into 13 circuits, 12 regional circuits, plus the federal circuit in Washington, D.C., which handles specialized cases like patent law. These courts review decisions made by district courts, focusing not on facts but on whether the law was applied correctly and fairly. Panels of 3 judges typically hear cases, though larger en banc panels can be used for particularly important matters. Their rulings establish precedent within their circuit, shaping how district courts under them interpret the law. 3. The Supreme Court of the United States. At the top sits the Supreme Court, the nation's highest judicial authority. With 9 justices, it has both original jurisdiction in rare cases, such as disputes between states, and appellate jurisdiction over cases from the circuit courts or state Supreme Courts. Each year, thousands of petitions are filed, but the court hears fewer than 100 cases annually, focusing on questions of broad constitutional significance or where lower courts have issued conflicting rulings. Cases reach the court through a writ of certiorari, a formal request for review. At least 4 justices must agree, the rule of 4, for a case to be accepted. This selective process ensures that the court addresses only the most pressing and nationally significant legal questions, allowing it to set binding precedents that apply across the entire country. Why the structure matters. This tiered design reflects the principle of checks and balances within the judiciary itself. District courts handle fact-finding in trials, appellate courts ensure uniform interpretation of law within regions, and the Supreme Court provides the final word, resolving disputes of constitutional and national importance. Together, the system maintains both accessibility, local courts for citizens, and unity, a single constitutional standard for the nation. Interpreting the Constitution. One of the most debated questions in American law is, how should judges interpret the Constitution? Because the text is often broad and open to multiple meanings, different judicial philosophies have emerged, shaping not only how cases are decided, but also the very balance between liberty and government power. 1. Originalism. Originalists argue that the Constitution should be interpreted according to the meaning it had when it was written and ratified. This approach emphasizes the intent of the framers and the original public meaning of the text. Originalists believe this method provides stability, limits judicial activism, and ensures that unelected judges do not impose their personal values on the nation. Prominent originalists include the late Justice Antonin Scalia and Justice Clarence Thomas. Under originalism, constitutional change should occur primarily through the amendment process, not judicial interpretation. For example, when deciding gun rights under the Second Amendment, originalists focus on what the right to bear arms meant to citizens in the late 18th century. 2. Living constitutionalism. In contrast, proponents of a living constitution argue that the document was designed to be flexible and adaptable. They believe that broad principles like equal protection or due process must be interpreted in light of modern values and circumstances, rather than frozen in the 18th century. Living constitutionalists argue this approach keeps the Constitution relevant to contemporary society, allowing it to protect rights in areas the framers could not have foreseen, such as digital privacy or same-sex marriage. Justices like William Brennan and Ruth Bader Ginsburg championed this view, seeing the Constitution as a dynamic framework that evolves alongside society. 3. The impact of these philosophies. These competing approaches often divide the Supreme Court on issues ranging from gun rights, District of Columbia versus Heller, 2008, to privacy, Roe v. Wade, 1973, Dobbs versus Jackson Women's Health Organization, 2022, to equality, Brown v. Board of Education, 1954, Obergefell v. Hodges, 2015. The justices' interpretive philosophy has shaped outcomes. Originalists tend to favor narrow interpretations rooted in history, while living constitutionalists are more likely to expand rights in line with changing norms. 4. A continuing debate. This debate is not merely academic, it reflects a fundamental tension in democracy. Should the Constitution be anchored to the past for stability, or should it evolve to meet new challenges? In practice, justices may blend methods, sometimes citing history, and at other times considering contemporary realities. But the underlying philosophies remain central to American constitutional law, influencing the court's legitimacy and the nation's ongoing struggles over rights and freedoms. Judicial politics. Although the judiciary was designed by the framers to be an independent branch of government, free from the pressures of day-to-day politics, in reality, it cannot be separated entirely from political forces. Courts interpret laws and the Constitution in ways that inevitably intersect with partisan debates, public opinion, and the broader political environment. 1. Judicial appointments as a political process. The process of selecting federal judges is deeply political. Presidents nominate candidates who reflect their ideological views, often hoping to shape the judiciary long after their own terms end. For example, Franklin D. Roosevelt appointed justices supportive of the New Deal, while Ronald Reagan sought to strengthen conservative constitutional interpretation. The Senate, which confirms nominees, also plays a political role. Partisan control of the Senate often determines whether nominees are swiftly confirmed, delayed, or even blocked. Controversial confirmation battles, such as those involving Robert Bork, 1987, Clarence Thomas, 1991, and Brett Kavanaugh, 2018, highlight how politically charged the process can become. 2. Judicial decision-making and ideology. Although justices claim to apply the law neutrally, their interpretive philosophies often align with broader ideological and partisan divides. Conservative justices tend to favor originalism, judicial restraint, and limited federal power, while liberal justices more often embrace living constitutionalism, judicial activism, and expansive interpretations of rights. These differences explain why closely divided courts often split 5-4 along predictable ideological lines on issues like abortion, affirmative action, or voting rights. Yet, it is important to note that justices sometimes defy partisan expectations, demonstrating that law and principle can temper ideology. 3. The role of public opinion in judicial legitimacy. Unlike Congress or the presidency, the judiciary has neither the power of the purse nor the sword. It controls no army, and it cannot fund its own initiatives. Instead, its legitimacy depends on the respect and compliance of the public and other branches of government. Landmark cases like Brown v. Board of Education, 1954, and Roe v. Wade, 1973, illustrate how court rulings can both shape and be shaped by public opinion. If the court drifts too far from public sentiment, it risks eroding trust, as seen in debates following Bush v. Gore, 2000, or Dobbs v. Jackson Women's Health Organization, 2022. 4. The paradox of judicial politics. The judiciary is thus caught in a paradox. It must remain independent enough to uphold the Constitution against political pressures, yet it cannot escape the political realities of its appointments, decision-making, and public reception. The balance between law and politics in the courts continues to be one of the most important and contested features of American democracy. Landmark Supreme Court cases. Over the course of American history, the Supreme Court has issued decisions that profoundly shaped society, law, and politics. These landmark rulings demonstrate the court's power to both expand and restrict rights, often sparking intense public debate while leaving lasting legacies for generations. 1. Brown v. Board of Education, 1954. This unanimous decision struck down racial segregation in public schools, declaring that separate but equal facilities were inherently unequal. Overturning Plessy v. Ferguson, 1896, the court ruled that segregation violated the Equal Protection Clause of the 14th Amendment. Brown became a catalyst for the civil rights movement, showing how the judiciary could advance social justice even against entrenched traditions. 2. Miranda v. Arizona, 1966. In this case, the court held that suspects in police custody must be informed of their constitutional rights before interrogation, including the right to remain silent and the right to an attorney. The Miranda rights are now a staple of law enforcement procedure, reinforcing protections against self-incrimination under the Fifth Amendment and ensuring fair treatment for the accused. 3. Roe v. Wade, 1973, and Dobbs v. Jackson Women's Health Organization, 2022. Roe v. Wade recognized a woman's constitutional right to an abortion under the right to privacy implied in the 14th Amendment. For nearly 50 years, Roe set the framework for reproductive rights in the U.S. However, in 2022, the court's decision in Dobbs overturned Roe, returning abortion regulation to the states. Together, these cases illustrate how constitutional interpretation can dramatically shift, expanding rights in one era and contracting them in another, often intensifying partisan and cultural divides. 4. Obergefell v. Hodges, 2015. This decision held that the Constitution guarantees the right of same-sex couples to marry under the equal protection and due process clauses of the 14th Amendment. Obergefell was a major milestone for LGBTQ+ rights, placing marriage equality on the same constitutional footing as other fundamental rights. It also showed how evolving cultural norms influenced the court's rulings, reinforcing the debate between originalist and living constitutionalist approaches. 5. The broader impact of landmark cases. Each of these decisions underscores the judiciary's unique role in shaping American life. The court not only interprets the law, but also defines the boundaries of liberty, equality, and justice. Sometimes its rulings accelerate social change, Brown Obergefell, while at other times they provoke backlash or reversal, Roe Dobbs. What remains constant is the court's central place in American democracy, a forum where the most contested questions of rights and governance are ultimately decided, strengths and criticisms. The judiciary provides crucial benefits, protecting minorities, ensuring the rule of law, and stabilizing democracy. But critics argue that unelected judges wield too much power, that lifetime appointments make them unaccountable, and that decisions often reflect partisan ideologies. The debate between judicial activism, courts shaping policy boldly, and judicial restraint, courts deferring to elected officials, remains central. Conclusion. The judicial branch is not just a legal institution. It is a political actor that influences nearly every aspect of American life. From civil rights to campaign finance to healthcare, the courts decide questions that affect us all. Yet their power rests on a delicate foundation, legitimacy and public trust. As we continue through this course, keep asking, should courts lead in protecting rights even when unpopular, or should they defer to the democratic process? That question remains one of the great tensions of American politics. Next time, in Chapter 14, we will turn back to the people themselves, exploring public opinion and its influence on the political system.